I'm delighted to be here today to talk about the BC Act and hopefully not cover too much territory that Ken went through before. And the focus of what I'm going to talk about is really helping you as consultants understand some of the provisions in the legislation that are a bit bitey. And I'm going to wrap up with my tips on how to mitigate the risk of being hit with the sharp end of the Biodiversity Conservation Act stick. Who doesn't like a quokka selfie? Had to find a way to make this a little lighter, otherwise it would tend to be very dry. So, it seems to be a rite of passage now for those going to Roto to take a quokka selfie, an Instagram-worthy picture. And certainly Roger Federer managed to break the internet with his, I think it was last year or this year, watch out Kim Kardashian. But the quokka selfie is a great example because it's actually an activity that potentially could get you into a bit of trouble under the BC Act, as it could be disturbing fauna, which is an offence. There are various ways that you could be liable, but I think it's arguably an activity that has the effect of altering the natural behaviour of the quokka to its detriment. Encouraging quokka vanity, I think, would be detrimental, wouldn't it? And the potential for harm, interestingly, is actually being recognised by Instagram. So if you look for this hashtag, I think you do get a warning that comes up, which alerts you to the fact that Instagram doesn't promote harmful activities to animals. So maybe they're also aware of the BC Act and want to make sure that they've got their ducks in a row as well. Exactly. So to make sure that we keep the discussion on the legalities of the Act and how they might apply to consultants light, I'm going to use the quokka selfie as a bit of a case study, if you'll allow me to. I'm not going to spend much time talking about what the Act does. I think that Ken gave a comprehensive overview of what the Act does. It's mostly not in force at the moment, and it will take effect for the most part once the regulations are in place. Okay, so what are the key implications for consultants? There are a whole range of provisions which will impact the work that you do for clients. You'll be assisting them navigate the new processes under the Act. And there are also a whole range of offences which are aimed at providing a comprehensive regime for protection of flora and fauna in this state. I'm not going to focus on those two aspects of the legislation. What I'm going to focus on today is the duty to report, which I see as probably the single most important provision for consultants to get their head around and have processes in place to reduce your potential exposure to liability. But I'm also going to talk about some provisions that, as a consultant, you may not necessarily turn your mind to. They're down the back of the Act, and they're in the legalistic part of the Act, if you like. But they're ways that you may attract liability for offending that you personally haven't been involved in. So the accessory to offence provisions and the extended liability. Appreciate down the back you might not be able to read these provisions, but what I've set out here is the duty to report. There are two separate duties to report, one relating to flora and one relating to fauna. It's a somewhat unusual obligation because typically when you've got positive obligations along these lines, they apply to people who are doing things, to the proponent project, someone who's developing or clearing or whatever it may be. But here it's going to apply to people who are out there undertaking survey work for the purposes of somebody else's project, generally speaking. So I just want to run through a couple of aspects of the provisions. I'm going to echo Denise's comments around the clearing regulations. I'd really encourage all of you to look at the legislation and really read and understand the obligations that are contained within. It's not something that you need a lawyer to assist you with, and it will really, it's the first and the most important step in mitigating your potential liability. So first, when does the duty arise? It doesn't arise for all field work. It's only field work that's associated with a Part 4 assessment or in relation to an application for a clearing permit. So if you are instructed to undertake work that's pre a Part 4 assessment or post, you won't be caught. So understanding the scope of the duty is the first thing. Second thing to note is that there's no time frame for reporting. It's an ongoing obligation. As Ken mentioned, there's a defence that if you don't know what you've seen is threatened flora or fauna, you don't commit the offence. But if at a subsequent point in time you do understand that, that reporting obligation continues to kick in and you will need to make a report. One interesting aspect is that the section applies to a person who's carrying out field work. So every individual who is engaged in that activity holds that obligation personally. So it's not just the consultant who's taking the lead, it's all persons engaged in the field work. So thinking about when you have a group of people undertaking a particular job, how you're going to go about making the report to avoid duplication is important. And just to reiterate probably the obvious, ignorance of the law is not an excuse. So there's no defence that you didn't know about this duty. And even if there was, for all of you sitting in the room, I would have ruined that for you. But ignorance of the fact. So insofar as you come across a particular species and you don't understand its status, then that is a defence to if you fail to report that particular species. Okay, so we're on Rotto, and we've seen a quokka, and I'm assuming that it will be a species that will be captured by this new duty to report. If we're there on a work retreat, we don't have a duty to report. If we're there undertaking surveys because of a Part 4 process that's going on for new development on Rotto, then that's when the duty would arise. Okay, so moving on to some of the more legalistic aspects, but I think these are really important for consultants to understand. My assumption is that as diligent environmental professionals, you won't be in the habit of being out there committing offences under the BC Act. But how you engage with other people who may commit offences may expose you to liability. There are a couple of ways that can happen. I'm going to start with the accessory provisions, but the extended liability provisions are also worth noting. So section 234 talks about accessory after the fact to an offence. So you can be exposed to liability if you know that someone has committed an offence and then you help them avoid punishment. So that's what accessory after the fact to an offence means, except if that offence has been committed by your spouse. So, bit of wriggle room there. So helping someone avoid punishment, what could that be? That could be changing a report. It could be, in the case of the quokka, deleting the selfie if it was on your phone. So it's the sort of activities that you might be asked to make by a client potentially, or perhaps not the clients that people in the room act for, to avoid them facing liability for the offence. Well, if you engage in that behaviour, even though you weren't the person who committed the offence in the first place, then you're still likely to attract liability. So this is the accessory provision that's built into the BC Act, but it's also important to understand the application of the criminal code generally. It will apply here, and there are other provisions which may extend liability to those broader set of persons than those who physically commit an offence. So anyone who aids somebody generally in the commission of offence or encourages, etc., then you're potentially liable as well. The other aspect that will be relevant, and this is particularly for those amongst you who own consultancies or are directors or in positions of authority within consultancies, is that the Act will operate such that you are liable, you may be liable, for offences committed by people who work within your organisation. So I've popped up here the particular provision which applies to the employer-employee relationship, because I thought that might be most relevant and come up most often. But there are similar provisions that operate in respect to liability for directors and executive officers for the actions of bodies corporate in partnership, so amongst partners, and also agent and principal relationships. And so the gist of this is that if your employee commits an offence, you as the employer are also deemed to have committed the offence. So there's no need for any additional evidence. And it doesn't matter whether the employee was on a frolic. You could have told them not to do it and you're still potentially liable. An employer is also exposed, irrespective of whether the regulator takes action against the employee. As I mentioned, deemed liability, so there's no need for any additional evidence, any additional consideration. If the employee has offended, you are deemed to have offended as the employer. Now, this may all sound scary, but good news, there is a defence available. And there are two limbs to the defence. So the first is that you as the employer didn't consent to the action of your employee. The second, and this is probably the most important aspect, is that as an employer, you took reasonable precautions to prevent the specific offence occurring. So it won't be enough that you generally had systems in place to offend non-compliant conduct with legislation, for example. You need to have particular measures that you can point to and evidence in respect of those, that systems are in place directed at the offences under the BC Act. Okay, so back to our Quokka example. It's a retreat on Rottnest and your employee takes that photo, you're on the hook. You're on the hook unless you've got evidence to show that you didn't consent, and not only did you not consent, you specifically had put reasonable measures in place to stop this kind of conduct occurring. So that's all I'm going to say on the provisions of the BC Act. The Act is comprehensive and there are a whole multitude of provisions that you'll interact with. But in terms of a lawyer's perspective, I think that those are ones that are important to take into account and understand ahead of this part of the legislation becoming effective. So it's not all problems, I come with solutions for you. How to mitigate your potential liability. So the first is to understand the law, read the law, get a good handle on what the obligations are that apply to you, as well as the obligations that apply to your clients. And then I've got a few points up there about things that you can do that are really aimed at having reasonable precautions in place, putting measures in place to stop people within your organisation offending. So processes, procedures, training, education. First and foremost, you'll do these things not to preserve your defensive position, but to avoid getting into the position of offending in the first place. But should that happen, they're really important to be able to put evidence towards a defence. And this is similar to the kind of evidence that you would need for EP Act defences. So have the same kind of mindset when you're thinking about the Biodiversity Conservation Act. In addition to procedures, you need to supervise. So as an employer, you need to have adequate supervision of your employees. And similarly, if you are in the position of director or exec officer of a corporation, you've got to have adequate supervision of the business and the activities of the corporation that you're working within. Without supervision, you're highly unlikely to be able to rely on the defence. And audits really help. One point on audits is if you're doing an internal compliance audit and you find some areas for improvement or issues, don't sit on those. That can actually provide detrimental evidence if you've known about a problem and you've not addressed it. So if you do decide to be proactive and audit your own compliance, don't leave issues to fester. Last point, it's probably self-explanatory, don't be a party to a crime. So understand where your exposures might be, and particularly in respect of the duty to report, understand it's a personal obligation. I think that consultants are going to need to think about their terms of engagement with their clients to ensure that you don't have any contractual difficulties in discharging a statutory obligation, because that will apply irrespective of what arrangements you've made with your clients. So my recommendation would be to be upfront with your clients in terms of the obligation that you have as individuals under this legislation, and to make sure that the terms on which you engage with your clients allow you to discharge that obligation without needing to go and seek their consent or any other issues. So that's all I've got today. Any questions? I'd be happy to take them.
Mel, just quickly, you refer to consultants. The reality is there's people in this room that aren't consultants that will still have the same obligations because they work for a company, and as part of their job they do that stuff for the company, like a miner they often do. Can you just put a bit of context around that? Because I think that's really important. It's not just consultants in the classic sense, it's more broader.
That's exactly right. So it applies to any person. So if, for whatever reason, I went out on site as part of the party that was doing a survey as part of a Part 4 assessment, I personally would have an obligation to report if I knew that we had discovered a threatened species. So it is wide-ranging. There's an interesting question as well about whether the company that you're working for is also a relevant person involved in that survey work and also itself needs to report. I think it's arguable that they do. So having a system in place to make sure that you capture that obligation for proponents, for anybody involved in this survey work, for consultants, anyone that's involved in that work from your side, and where other individuals may be involved for whatever reason. I mean, they should understand the impact of the law, but assisting them and educating them as well.